Welcome everybody to Crypto Law. This is Meta Lawman James Murphy, and today is Tuesday, June 25th, and we've got a fantastic show teed up for you today. We have a very special guest, Kallen Long, CEO of Custodia Bank, as well as a litigator extraordinaire who's working for Custodia Bank in litigation with the Fed, and that is Michelle Kallen. Kallen and Michelle, welcome to Crypto Law.
Thanks, James. Great to be back with you.
Thanks for having us.
Absolutely. Kallen is well known in the crypto community, and with good reason. Kallen is a Wyoming cowboy through and through. Went to college at the University of Wyoming and then on to Harvard Law School, and then into the belly of the beast, 22 years on Wall Street, where somewhere along the line she picked up an interest in Bitcoin. And as they say, the rest is history. Michelle Kallen is with the law firm of Jenner & Block in the Washington, D.C. office. Michelle and I have a couple of things in common. One is we both went to Vanderbilt Law School. Michelle went to, as a Stanford Cardinal undergrad, but we both went to Vanderbilt, but I believe I may have graduated a little bit before Michelle, like 2 decades before. Michelle was the Solicitor General of the Commonwealth of Virginia, which is amazing to have done so early in a career. As I was reading up on Michelle, I was thinking, of all these awards and all of these positions, this sounds like somebody who's been practicing for 30 years, not 14 years. So Michelle, congratulations on really an outstanding beginning to what I'm sure is going to be a long and very, very successful career. And it's wonderful to meet you.
It's great to meet you too.
All righty. So what we're going to talk about is arguably the most important case in crypto. And so some people may challenge that idea, but after they listen to this show, they may just change their minds. And I've seen Kallen change minds when explaining the ramifications of this really, really important case to people. And so let's start to just set the table with, if you would, what is Custodia Bank and what makes it such an unusual business model for a bank?
Well, it's a bank. We are a depository institution legally, which from a legal perspective is a type of corporation that is bestowed by law with the right to create US dollars. You have to be a depository institution to do that. There are other types of financial institutions like trust companies, like money transmitters and the like, but only depository institutions are actually banks. And we are a bank. The Fed actually said so in a public document. We are a depository institution eligible for what's called a master account. Why is that so important? A master account is a bank account for banks. You have to be eligible. You have to be a depository institution eligible under the law to bank directly at the Fed in order to get one of these master accounts. Although the Fed has not, shall we say, adhered to the law, both giving ineligible, denying eligible companies like Custodia master accounts against the law in both cases, and is trying to engineer so that it literally has no check and balance, nobody checking its work, no judicial review of its decisions, etc. I'm sure we'll get into that. But why is this a crypto case? Tyler Winklevoss last week said it so well. We're in the midst of Operation Choke Point 2.0, and that has that started under this current administration, where, frankly, we've seen this before, where the crypto companies lose bank accounts for no good reason, due to no fault of their own. And that what's happening, Godfather-like, behind the scenes, the bank regulators are pressuring the banks to close the bank accounts. Tyler said it in such an eloquent way. That's a nice bank you've got there. It sure would be a shame if you got enforcement actions. Wink, wink, nod, nod. That's what happens behind the scenes with the bank regulators trying to get crypto companies debanked. And Custodia has experienced that twice due to no fault of our own. And we can attest from what we see on the customer side as well that Operation Choke Point 2.0 is alive and well still, unfortunately.
Well, Caitlin, you said a lot there. I made a few notes before this conversation, and you touched on everything. So if you don't mind, I'd love to drill down just a little bit on the beginning and the process. You've explained a master account is essential. If you're going to be, providing service to customers, you must have a master account, or it becomes really, really cumbersome and difficult. So if you could kind of start from the beginning, you did everything you were supposed to do in applying for the master account and taking in comments from the Fed or the Fed and bank in Kansas City and responding to them timely and all. But can you just fill everyone in on your process? Because when I looked into it, what I found is master accounts are granted in like a week typically. So what happened?
Well, we know a lot about what happened, obviously, because there's active litigation. I won't go into more details than just the facts. Custodia went through a full-fledged bank chartering process in Wyoming, and that was a 10-plus month process. Public hearings, public investigation. The Wyoming Division of Banking did a big investigation on our business plan, background reports on our executives and our directors, all the things to get chartered as a bank that are normal. And the Wyoming Division of Banking produced I don't know how long it was, I never saw it, but a long investigative report about Custodia's business plan. And then this went to a public hearing, and the banking board voted 7-0 unanimously to grant Custodia a charter after the Division of Banking recommended charter. But the point is, there was a whole process. It's not like Wyoming willy-nilly gives out these charters. It's a full, long process. Right. And then we applied for an account immediately thereafter. And you're right, the master account application is one page. Why is it only one page? Because historically, the Fed respected the chartering work of the chartering agency, which is either going to be the states, the 50 states, or a territory like Puerto Rico, for example, or at a national level, the Office of the Comptroller of the Currency, OCC. So the Fed is not a chartering authority. It has no ability to charter any financial institution. It's a service provider that provides access to the US dollar payment system. Just like the FDIC is a service provider, it provides access to the industry's insurance fund. Those two things are utilities, the payment system and the insurance fund. There's a reason why policymakers separated the chartering decisions from those two utilities, the payment system and the insurance fund. They wanted the chartering decision to be done separately, and they wanted those utilities to be available to everyone in the industry. Well, as we know, they are not. Custodia applied for FDIC insurance and was turned away because of the crypto aspect of our business. We got a wink and nod from the general counsel of the Fed along the way that we should apply to become what's called a Fed member bank, which would have made us directly regulated by the Fed. We did so, and they used the information that we provided as part of that process against us in the end.
Well, Caitlin, I read all of the briefs and a lot of the exhibits because you had explained to me how important this case is, and it was to me, shocking, and I'm not easily shocked. I mean, some of it was safety and soundness, the capital plan. Well, your capital plan is to retain 100% plus reserves, as opposed to what is typical everywhere, which is a fractional reserve approach, which is by definition about as safe as you can get. And the second thing that I found funny was they were critical of the experience of the leadership team. And I've got to tell you something. I grew up in small towns in the South. Every small town in the South has a bank. And the bank president is generally the mayor, the owner of a hardware store, whatever. Some guy's done well in the community and decides, this community could have a bank. And that becomes the CEO of the bank. And these people get master accounts. And meanwhile, we have a Harvard law grad with 22 years at the top of Wall Street, and they're critical of that. It's just quite shocking and almost laughable. But of course, it's not laughable because of what it means, in terms of this exercise of raw power in the face of facts that don't match up for what they're saying. And so you mentioned that this feeds into, obviously, this Operation Choke Point 2.0, because logic is not on their side in terms of the capital safety plan and the knowledge, experience, and sophistication of a leadership team. You can't ask for better. And so it doesn't make any sense. And that's why you've got to look for, well, what is the real reason here?
Well, it was Operation Choke Point 2.0. It's the Warren wing in control of all the federal regulators. And this is exactly what Tyler Winklevoss's tweet last week was speaking to. He called out the FDIC and OCC, and I came over the top and said, hey, the Fed's doing the same thing. They are definitely targeting and we know this, there's a lot more that I can't share, but they are definitely targeting the banks that are serving the crypto industry. They're trying to kill all of us. And your point is well taken, James. It's funny because as time went on, it's become clearer and clearer just how political the denial of Custodia was. At the time, since we were at the tip of the spear of Operation Choke Point 2.0, it was bewildering. I just couldn't believe some of the things that they were saying. They was just absolutely ridiculous and incredulous. And as more and more time has gone on, I don't think anybody's out there defending what the Fed said about us. Most people are taking shots at it because it's just outrageous. They went so over the top to try to make us seem like we were absolute idiots. And of course, there's Michelle and I talk about this a lot. There are only 18 women-owned banks in this country out of 4,236. Wow. And here comes a women-owned bank. Wow. And what do? They start saying the same kinds that, whites-only country clubs said about people in the 19th. Oh, you don't have the right background, right? Encouraged. I actually filed a complaint with the Inspector General. And one of the things I said is for them to review what happened on that comment about experience, because it was so obviously untrue. And they targeted a woman with that. Go think about that when there are only 18 women-owned banks in the country. So here, Michelle and I are locking arms, having fun, bringing this appeal and talking about this is just nuts. And that's part of the reason why she was so interested in the case and so passionate about it.
It's spot on. And Michelle, kudos to you for taking this really important case on, and I think you've got a wonderful background, in appellate advocacy. And I see you received awards for best brief. I hated briefs when I was practicing law. I'm semi-retired now because I hated the drafting and redrafting and editing of briefs. And in big cases, there's always so many cooks in the kitchen, who want to make this change, or it's some other group what doesn't want that change, and they don't communicate. Lawyers in the middle. But in any event, listen, you've taken an appeal. You filed a notice of appeal at the 10th Circuit Court of Appeals. And for people who are not lawyers, most people watching this are not lawyers. You take an appeal because you believe the judge got something wrong, or more than one thing wrong. Can you give us a sense of what the position is of Custodia Bank about what this judge got wrong?
Sure. So I can definitely speak to that at a high level. And this case in particular really speaks to me because it involves the interplay between states and the federal government. And banking is unique in that it's governed by the dual banking system, which is about equal roles between the states and federal entities in chartering banks, and that respect. Actually, the Supreme Court just this past term, just a couple of weeks ago, highlighted the dual banking system, this idea that states and federal entities kind of share the role in governing banking. And so as someone who comes from the state government world and someone who's used to invoking federalism, this case was really compelling because here we have a state chartered bank, chartered and regulated under state law, that is being treated differently and worse than federally chartered banks. And so that's one of the issues that was really at play before the district court, and something that we think is really important as the case proceeds, is the importance of the dual banking system and the respect that Wyoming's law, chartering banks and then regulating banks, the respect that those laws deserve.
Yeah, this is so important. Caitlin has been talking about this forever, the dual banking system and its importance, and how the federal government can really undermine that design, that intentional design. And it looks like it's happening here. Help the viewers understand what you all would like to accomplish through this appeal. I understand there are similarly situated banks seeking master accounts. Are you kind of looking for a decision that Custodia is entitled to a master account, or are you looking for a remand with instructions that the judge just read the rules wrong? Or how are you all thinking about that?
So I'm happy to get started, but Caitlin, feel free to jump in. This case was brought because Custodia was wrongfully denied a master account, and Custodia is looking for a court to vindicate their Custodia's interest in a master account. So I think that the complaint is pretty clear that that's what Custodia is seeking in this case. The Custodia's legal theories are tied to statutory interpretation. And so the court's interpretation of the relevant statute will also be relevant to other entities that are seeking master accounts. But as a lawyer here representing a client, my client sued to get a master account, and that is the interest that we're seeking to vindicate.
I think Bill said Fed is trying to unilaterally.
Yeah, go ahead.
The Fed is trying to unilaterally overturn the dual banking system. And as Michelle correctly said, just a couple of weeks ago, the Supreme Court reiterated we have a dual banking system with parallel state and federal banking systems with equal powers. And there is no such thing. And historically, from 1980 onward, there was no distinction at the Fed regarding who got access to the payment system. There was a deal cut in Congress, but it used to be that the Fed was only operated for its member banks. But in 1980, because there were some intricacies with interest rates spiking, and the Fed was not paying interest on reserves to the banks, and so it became uneconomic for banks to be members of the Federal Reserve System. They were leaving in droves, and so Paul Volcker actually begged Congress for the Monetary Control Act of 1980, which brought them all back into the system, required every bank every depository institution in the United States to hold reserves, regardless of whether it's state or federal, inside the system. And the trade-off that was made was that every depository institution that was legally eligible access to the payment system, full stop. There was no such thing as the Fed being able to second guess the chartering authority. And to Michelle's point, the Fed set up these guidelines that have these 3 tiers. The state chartered banks that have not been able to get FDIC insurance are relegated to not just second-class citizens, but third-class citizens. They are absolutely trying to overturn, insidious way, the dual banking system. And so therefore, marching all the way up if we have to.
You broke up just a little bit there, Caitlin. Just to make this as clear as possible to our viewers, when a depository institution is chartered by a state, does the state banking authority become the primary regulator of that depository institution? Yes. Okay.
Yes.
So I think you've made a really critical point before. If the Fed has the discretion to refuse to grant the master account to a state chartered bank, they also then have the discretion to pull it at any time if they don't like your business, but they're not the primary regulator of that bank. Is that correct?
Yes, pretty much.
Yeah.
And yeah, go ahead, Michelle.
Well, I mean, it enacts an effective veto on a state charter, right? And it reflects this inherent distrust of states and their efforts to regulate, and that's just antithetical to the dual banking system.
And if you have, in fact, a whole of government operation to choke out a legal industry, it's hard to imagine a better weapon than to pull the charter of a bank if it takes on customers and business that the government doesn't like for any reason. And by the way, we do have probably crypto friendly crowd here, but you have to think about this more broadly, right? I mean, this isn't just about crypto. It could be, pro-choice or anti-abortion, advocacy businesses, or, Second Amendment, or whatever, transgender right, whatever is out of vogue at any time would suddenly be at risk. And in our society, losing your bank account is really, really serious.
Right. And Davis Polk, in the analysis of the district court opinion, said essentially what you just said. This is dangerous. It's not what Congress authorized. This is why the equal and universal access of all eligible depository institutions was put into the 1980 Monetary Control Act. And the Fed from 1980 until recently actually behaved that way. Again, that's the reason why the master account application is 1 page. There's no concept of rechartering by the Fed once the chartered depository institution gets its charter and goes and applies for a bank account at the Fed. There was no concept of that in the law, and yet the power for itself, and it is absolutely prone to abuse by whomever is in charge at the White House. And the reason I underscore the White House is the White House was involved. Again, now we know back then it was bewildering that the White House was involved, but the White House was involved. We knew this because in our case, Bloomberg got a leak 2 days early, and they were putting so much pressure on us to withdraw our applications. That's the other thing that happens in the banking world. The bank applicant voluntarily withdraws. Well, of course, it's with a gun to the head, proverbially, right? And that's what happened to us. And they were afraid we weren't going to withdraw, so they used the press to pressure us. But we ended up figuring out that the White House was involved, and we had subsequently insiders come forward that were confirming that what the press people had told us, that the White House was in orchestrating this. And again, the Fed's supposedly independent. So it was really bewildering at the time to believe that the White House was involved, but now we know that it is. And unfortunately, there's a lot more that we've learned in the last 20 months or so since that January 2023 denial that has happened against our industry. But we continue to see another wave of crackdown on the traditional banks that are providing U.S. dollar banking services to the crypto industry, and Custodia in there just fighting to stay alive, to just get to the other side of what we're facing. But I will tell you, it has not been easy, because the debankings that we have experienced, as I testified publicly, in one case, debanking ended up impacting 1.5 million lines of code on our platform. That set us back by many, again, modularized, but still many months. So the Fed, it is not an understatement to say the Fed is trying to kill all the crypto companies, and all the other federal bank regulators are in this with them. That's what Operation Choke Point 2.0 is. Again, Tyler Winklevoss's tweet was so apt in its description. And we're just fighting this. This is not legal. It is wrong. And we're at the forefront of being willing to fight it. We were not willing to back down and withdraw our application and go quietly into the night.
Well, look, Caitlin, you're a hero for a reason, because what you're going up against isn't just any bully. The government, I know the Fed's supposed to be independent of the government, but nevertheless,
it's not.
It's the most powerful bully on the planet. It's not just some bully, and so they have a lot of levers in addition to bleeding you out on legal fees, and I'm amazed and grateful that you're willing to take this on and foot this bill. I mean, you got great lawyers. They're not cheap. When I was practicing law, I wasn't cheap. That's kind of how it works. But really respect what you're doing. And on your point, kind of the politics, this is a question I had. I don't know if I've heard you speak on this in particular. You have talked about Operation Choke Point 2.0. Your situation is different than the rest of crypto. The rest of crypto believes that if there's a change of administration, there's going to be a change in leadership at the SEC that is going to be a profound change. And you could conceivably have someone like Hester Peirce elevated to the chairperson, and the new administration would have 3 of the 5 votes going forward, and there would be significant changes. And the reason we know that is Hester Peirce has made her views very clear about cases that have settled, and she said, I would never have brought the case in the first place. So she's signaled very clearly that would change, number one. And number two, it seems as though the crypto is making some progress on a market structure bill in Congress, which if it passed, then there would be clear rules that the Coinbases and others in the space that could then comply with. But your situation is a little different because of this concept of the independence of the Fed, at least as it with respect to monetary policy. So what I want to understand from you is there a way to solve for this philosophically at the Fed by changes of personnel or something, so that there doesn't have to be this constant trip to the court when they act inconsistently with the law? So the regular crypto people think we're on to something and making progress. How do you think about the banks, where they've got to deal with the Fed, where the president, the relationship is a lot different?
Well, it is public information that there was a meeting after FTX failed with Fed Vice Chair Michael Barr, who is one of the Warrenites in the Biden administration, about Custodia. So it is a fact that 2 weeks after FTX failed, Michael Barr has a meeting about Custodia, and then just a few days later, the first draft of the denial memo appears. So you connect the dots. So we know who did it. And would that change over in a new administration? Probably. There's some very interesting intricacies of how the Fed works. It's so interesting because just like the Supreme Court has 7 justices, the Fed has 7 governors, but they don't behave independently like the Supreme Court justices do, where each one is a single vote and they are truly independent and they don't try to create unanimous decisions. The Fed, by history, has tried to vote unanimously. What the impact of that is, and I've talked to several insiders who have confirmed this at the Fed, the impact is that the most powerful people at the Fed are not the Fed governors. The most powerful person is the chair, but then the most powerful people are the senior staff, because the Fed has to get unanimity. Now, the Fed governors have 14-year terms. Unlike the Supreme Court justices, they're not lifetime terms. But there's also another aspect, which is the tradition is that the Fed governors don't serve out their 14-year terms. What does that mean? It means that new presidents typically do get to replace Fed governors more so than what would normally have been the case if they actually served out their 14-year terms. So it becomes more political. That's where I'm going. So we'll see. Is a Warrenite Michael Barr going to stand down if Biden is not reelected and either Trump or Kennedy is? We don't know the answer. He technically would not have to. There's a big debate over whether Trump could or Kennedy. Kennedy has publicly said he would dismantle the Fed. Trump has publicly said he would fire Powell. Well, pretty clear has the right to fire the chair, but he doesn't have the right to require a governor to not serve out that 14-year term. It's just been the tradition that they don't serve out the 14-year term, and therefore that there is turnover. So I think the Fed is not only going to become political, it already is in the presidential race, but it's also going to be very much on the fault lines of the fight, depending upon how the presidential election turns out and who wins and what they plan to do. I've worked with people on both sides of the aisle. I've disclosed this, not certainly the Biden administration. The Biden administration clearly has a bazooka aimed at us, right? So why would I help them? But I have helped multiple people in both political parties as well as independents, and learned a lot about what the planned policies are of the different candidates along the way. And I will say there's if either Kennedy or Trump is elected, there are going to be major changes at the Fed.
Well, we're running a little bit low on time. I just have two more questions. I'm going to give you a heads up, Michelle. My last question is predictions. So if you think of a prediction, that's what I'm going to finish with. But Caitlin, you put some bait out there on Twitter about this conversation we were going to have. It gets pretty esoteric when you start looking at the list of entities receiving master accounts. You've dug into the data and found some things. I'd love to hear, what you're seeing there in the context of Custodia, the safest conceivable bank structure I've ever heard of, with a phenomenal leadership, doesn't get a master account. What are you seeing on that list of entities that are receiving master accounts?
Well, I've said this before. The Senator Toomey is the one who required the Fed to disclose who holds master account. Right. And the first disclosure happened ago. And then we've had quarterly updates ever since. We have 5 databases now. And it's more than 9,000 different master account holders when you add up all the credit unions and the banks. And then, of course, the CME and, clearing houses, et cetera. And also like the bridge banks, for when the banks fail, the Fed sets up a new account for the bridge bank that it has the bank in receivership, those kinds of things. And so going through the data, what you find is that the Fed's database has obvious inaccuracies, and it has been an absolute mess. And I've said this before, every time they released a new update of the database, more accounts showed up, and you look at when the account was started, because that has to be disclosed as well. And in most cases, it was in the 1990s. Is it that the database updates are picking up accounts that have since the 1990s, but they weren't disclosed in the initial database updates? So if you step back at that, okay, where are the auditors? If a bank did that, if the bank could not produce for its regulator an accurate list of its account holders, what do you think a Fed bank examiner would do to that bank? Okay, and we've just had this incredibly awful situation with Synapse. Probably many of your listeners have heard about this. It's a fintech that was using these omnibus account structures that the Fed, because of how stingy it has become in recent years with master accounts, all these fintechs have had to use these FBO for the benefit of structures, which is an omnibus account structure. And apparently Synapse wasn't reconciling. There is a he said, she said going on, everybody's pointing fingers, but Synapse and its bank did not apparently reconcile dating back to 2017 is the allegation. Okay, so obviously they should have been reconciling, but they don't have an accurate list of who actually owns the different deposits and where those deposits went. And I look at this and think the Fed just came down like a ton of bricks on the banks involved in that situation. There was a consent order issued against Evolve last week, but the Fed itself does not have an accurate list of account holders. It does pretty clearly this quarter look like they finally paid attention to this. How many PhD economists and statisticians does the Fed employ? How can they not get the database right? There are obvious errors. And what by that I mean, there will be national banks chartered by the OCC, which by law have to be insured, and they're coded in the Fed's database as not having insurance. Just dozens of those. I mean, actually hundreds of questionable things, right? So this is what's fascinating to me is that there's been this question over the years of why is the Fed not audited? And that database itself, gasoline on the fire of that. It's just like the questions about the accounting at the Pentagon. Where did all this money go? And if you can't even get an accurate list of your own master account holders that you're required to disclose publicly, and they're not coded properly, it makes you wonder what's really going on and whether the most recent database is itself accurate. No one's asking the Fed to certify that's accurate, and apparently those databases are not being audited.
Amazing, really amazing. Hey, I'm going to tell a quick story. This is our out question, but I'm going to tell a quick story on you, Caitlin. You're not going to remember this. The first time we met was at a dinner with a few people in Denver, and it was during COVID. And so we were sitting out in a shack on the sidewalk instead of in the restaurant, where obviously the airflow is worse inside the shack than at a big restaurant, but that's COVID for you. So we were sitting there and had a great conversation. First time you and I had met. And as it was ending, I'm like, man, I don't want this to end. I'm sitting here with a genius on Bitcoin. And I said to you, what's the future? That's it. That was the entire question. And you didn't ask for any clarification at all. And you said two things: stable coins. At that, and then I just went back and looked. At that time, the entire universe of stable coins was single digit billions. Now, hundreds of billions of dollars are circulating in stable coins around the world. Check. Then you said Wall Street is going to financialize Bitcoin. Boom. We got futures ETFs, we got spot ETFs, we got leverage everywhere. And you said, so that check, got that one right. And then you said, and as a result of this financialization of Bitcoin, there is going to be you said Wall Street is not used to dealing with an asset quite like this. As a result, there's going to be the biggest short squeeze in human history at some time. You can't say when it is, but so your two have come true, and I'm waiting for the third. Give me another. I'm really hungry for Caitlin Long predictions because they're actually quite valuable. What are you thinking? What's the future, Caitlin?
Well, I'll give you one that's more shorter term and relevant to today, which is I think we're going to be in a rip-roaring bull Bitcoin market or presidential election. That's not a radical prediction because halvings are fundamental, and we're in a price dip right now. If you go back and look at the behavior of Bitcoin a few months after the halving, the price always dips as the shakeout occurs. Miners who can't afford to stay in business, and then they're liquidating. And when they sell Bitcoin, that is happening right now. And that is all going to, once that's done, we're back to the scarcity driving the price, and we'll get the rip roaring again, maybe October. So stay tuned. I predict that will be the case, and past will be prologue.
Well, just for our viewers, Caitlin is a bona fide certified OG in Bitcoin. I think you started in 2012, something like that. Your study of Bitcoin, I think, is what you told me. And I asked you why was the triggering event, and your answer was 2 words: Austrian economics, which thankfully my undergraduate degree is in economics, so I knew a little bit about what you were talking about. Michelle, here's what I've learned. I've been on Twitter for 2 years, and the only thing people want to know from lawyers on Twitter is what's the judge going to rule and when. They're really fixated on when. And, I try to break it to them. We don't know. The fact that we have a label called lawyer doesn't mean we have the answers to these questions at all. But anyway, I'm opening the door wide for you. What is your prediction that we should look for in the future, whether it relates at all to this case or anything else you think we should be looking for?
Sure. So I predict that issues involving crypto and blockchain technology generally are going to be something that's litigated in courts. It's something that's percolating on various issues across various metrics. It's something that's big in the administrative law world, where there's a question about the scope of agency power. That's a huge theme from this Supreme Court term. I think over the next couple days, it's something that people are going to be talking about a lot when the Supreme Court ends its term, likely at the end of this week. And so I think crypto really is at the forefront of those discussions, as is this case. And so my prediction is that we're going to continue talking about crypto and the law. And I think this industry really highlights some of the broader discussions that are going on in our society about the role of agencies and about the roles of states. And so I think this is a fascinating issue to be discussing. And I really can't think of a more interesting, meaningful case to raise these issues.
Spot on. Yeah, I think the Chevron deference is one of the things you probably had in mind that's going to be ruled upon. And people tend to think that's going to be overruled, that deference to interpretations of administrative agencies. And this major questions doctrine is like an amoeba getting bigger and bigger and eating more and more things that people kind of got used to administrative agencies doing. But in any event, listen, thank you so much. I honestly, this could go on for 3 hours. I'm so fascinated with this area of law and your willingness to fight, because you're not fighting just for Custodia Bank. You're fighting for all of us and our freedom, to invest our money or park our money or use our money in the way that we see best, that we get to decide that instead of some politicians in Washington, D.C. is so fundamental to who we are as Americans. And I feel like it's right there in the Constitution but it takes people like you willing to stand up. And I'm just really, really grateful on behalf of everybody who's watching and everybody who cares about freedom in this country. Thank you so much, both of you.
Thank you. Thank you to Michelle and team. Stay tuned, folks. There is a public clock. It is publicly available on our docket. So there will be, you will be seeing some things per the public. I'm really, really grateful to be working with Michelle and her incredible team on this case.
Fantastic. I will be watching. I'll probably be tweeting about it and certainly rooting for you. So thanks again. That'll be a wrap for this edition of Crypto Law. Thanks very much, everybody.